Good evening, folks. Yes, I know I said I wasn't going to do another video until tomorrow, but circumstances being what they are, I decided I needed to do one tonight. So, you might want to get out your notebooks for this one, folks, because we are going to cover the basics of a search warrant and what actually is entailed in those, and that way you guys can kind of get a better idea of what's going on there. So, as we have discussed before, and yes, I'm going to use the whiteboard for this because I firmly believe that all of you need to see this visualized. So, the United States Constitution covers the search warrants in the Fourth Amendment. Now, what it actually states in the Fourth Amendment is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. This is very specific language. However, as we all know, there are those that don't believe that it applies to them. So, let's go through a little bit. Now, this is the Fourth Amendment Constitution, Fourth Amendment to the United States Constitution. So, that makes this, the Fourth Amendment, that makes it federal. Right? Okay. Now, each state also has their own constitution, and usually it covers about the same thing, but sometimes it actually offers a little bit more protection than the federal constitution wording does. Now, whether it is state or federal laws, an officer cannot search you or your belongings or your house, anything like that, without reasonable justification. This reasonable justification is called probable cause. Now, the actual definition of probable cause is usually they see you doing something shady, or they have evidence to some degree. In the Stephen Avery case, probable cause was established for the November 5th search warrant because Teresa Halbach's car was found on the Avery property. So, there's that. Probable cause means that they have to be able to show the court that there's a good reason for you to be searched. And this probable cause must be established through a warrant. So they can't just like go into your shit and be like, oh, look at this, I found all this cool stuff. Now, a search warrant is a document that must be signed by a judicial officer, typically a judge. Now, this judge cannot just be any old judge, and he sure as fuck cannot be the judge that will eventually be tied to the case. He has to be neutral, meaning he has no vested interest in this at all. At all. Yes, I'm using notes, forgive me. Now, the warrant must include a detailed description of not only what is going to be looked for, but where they will look. They can't just say, oh, okay, well, we got a warrant for his car. His car is at his house. So, we didn't find what we were looking for in his car, so we're going to go in his house. They can't do that. They must get a warrant that states either both the house and the car, or they must get 2 separate warrants, one for each. But on top of that, this part covers where they can search within that location. So, again, we covered this last video. If they are looking for 100 pounds of cocaine, they can't look in your sugar bowl because you can't fit 100 fucking pounds of cocaine in your sugar bowl, right? Okay. Now, the U.S. Supreme Court once approved warrants that called for specified items together with other fruits, instrumentalities, and evidence of crime at this time unknown. That is an unusual case of a warrant that was very broad. Most warrants must be very specific, and only those specific items can be seized, except in one specific instance. That would be the plain view doctrine. If the police come into your house and they're looking for something, and, okay, say they're looking for a handgun that was used in the commission of a crime, but you just so happen to have a couple of rails of cocaine sitting on your coffee table. Because of that, it was right in plain sight. They can seize that and everything around it because it was right there. However, they cannot seize anything that wouldn't be typically associated with a crime, like sexual devices that were seized in the Stephen Avery case. That never should have been allowed. Now, warrants, while they do have to be somewhat specific, the most important thing they have to be is timely. They can't just go on and on and on and on and on and on and on. You have a deadline with which to work with. That's what this means, folks, is there is a deadline. You don't operate in that deadline, you need to apply for another fucking warrant. Or if you're coming close to the deadline, say that it gave you 48 hours, you're at hour 36 and you're looking around the joint going, shit guys, we're never going to get this done. You can apply for an extension of the warrant. But you cannot keep searching on that one warrant beyond that deadline. Otherwise, anything found after the 48-hour deadline could be considered inadmissible in court because it was seized illegally. Now, officers don't always need warrants to carry out searches. There's a few very specific exceptions to the rule. If they're arresting you, they get to pat your dumb ass down and they'll seize whatever the fuck they find on you. If they have to break into your home because they have reasonable belief that there's an emergency inside, goes right out the window. Okay? However, a few of the scenarios that allow law enforcement to act without a warrant is someone with control over the place or item gives them permission. So if they have permission, like the first time that Remaker showed up to Stephen Avery's house to talk to him about Teresa Hallbach, and he asked him, can I take a look around? Stephen said, go right ahead. Yeah, in that instance, that they don't need a warrant. The plain view doctrine, as we have already talked about. in the case of arrest, as we've already said, or in the case of what's known in law enforcement as a stop and frisk. However, there is one very important thing with regards to a stop and frisk, folks. For them to be able to stop and frisk you, they have to be reasonably certain that you've just committed a crime. And they cannot just go on like, oh, you're black. They can't do that. However, despite these exceptions, officers clearly need a warrant to get into some areas and execute a search. Like your house. If they don't have your permission to enter your house, they need a warrant. Officers occasionally need warrants in other situations too. But the search would be particularly invasive. So, like cell phones. That's a big one. They can't just arrest you and then go through your cell phone. They have to get a warrant to search through your cell phone. You just learned something. They also need a warrant to collect anything from your body. Blood, semen, skin samples, the cheek swabs. They need a warrant for that as well, unless you give them permission. But if you don't give them permission, they need a warrant for that too. Now, I'm going to just read this off real quick, and I'll put the link that I got this from down below, where I did most of my research. This place gives a really nice, clear, concise summation. To get a warrant, an officer must describe facts that establish probable cause to believe that whatever will be searched contains evidence of a crime. The typical warrant application involves a written affidavit, but sometimes officers can even apply by phone. The officer applying for the warrant must swear to the factual statements. Okay? So he has to say, oh yeah, I on my badge, I swear to the factualness of these statements. Now, exceeding the scope of the warrant is a big deal, and that applies in the Stephen Avery case. Because they exceeded the scope of the warrant by the number of times they entered each individual building that was listed in the warrant. They also exceeded the scope of the warrant by many of the items that were seized, such as pornographic material and sexual devices that were not listed in the initial warrant and that there was no probable cause to believe were necessary to be seized. At that time, and still, there is no proof that Teresa Halbach was raped. So, what the fuck did they take the porn for? Why did they take the sexual devices? It doesn't make sense. Now, this is what really gets me, guys. Before a warrant can be executed, an officer must provide what is known as a knock notice. What this essentially is the officer walking up to the door and going, police, we have a warrant. Okay? If you are not home or you refuse to allow them into your house at that time with that warrant in their hot little hand, they can then kick open your door and enter the domicile anyway. However, in the Stephen Avery case, Remacher did not provide a knock notice. He just kicked in the fucking door. Now, here's something that you have to understand. Suspects and their lawyers are not able to dispute the validity of probable cause on a search warrant before it is signed. And there is a very good reason for this. A search warrant is done completely ex parte. This is a legal term. Write that down. Ex parte is Latin for one party. That means only one person is involved. Now, this is a term that's used quite a bit in law. You can do a temporary motion for ex parte custody and custody battles. So there's that. But this is something that you do need to know, so you might want to write that down. Now, the reason why in this case it's called ex parte is it only involves law enforcement. Law enforcement is are the only people involved in swearing out a warrant. Now, if officers exceed the scope of the warrant, if they search beyond what the warrant allows, Remacher, Blank, Colburn, you listening? A judge will normally suppress the illegally obtained evidence. Willis, you listening? But the U.S. Supreme Court has ruled that the exclusionary rule does not apply if the police reasonably believed that the warrant was valid. So, unfortunately, in the Stephen Avery case, they can actually use that to state, oh, well, we had every belief that, that warrant was valid. However, they can only argue that up to a certain point since the warrant only specified up to 48 hours and only specified certain items. So, now that we've had a little bit of a class on warrants, we will do another one. I'll keep doing stuff like this. Try and educate you guys a little bit more, get you thinking. If you spotted anything that I misstated, by all means leave a comment. I don't pretend to be an expert. I just know what I know. So, if I gave any erroneous information or I was a little off on something, by all means, comment below. That would be great. I will leave the link for this down below in the description. Don't forget, guys, go to Facebook. Go to #Justice for Bryant to read all about Bryant Ellis. He was another young man that was railroaded by the Wisconsin juvenile judicial system. Don't forget to follow me on Twitter, MamaPhoenix6, and don't forget to subscribe. Thank you all very much for watching. We'll see you next video. It's not wanting to stop. Let's try this again.